Transport Authority. The purpose of this morning's meeting is to review the provisions contained in the draft statutory instrument for the Small Public Service Vehicle Consolidation and Reform Regulations 2014 with representatives of the National Transport Authority. On behalf of the committee, I would like to welcome Mr. Hugh Cregan, Director of Transport Investment and Taxi Regulation at the National Transport Authority. Apologies have been received from Mr. Jerry Murphy, who cannot be here. I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person, persons or entity by name or in such a way as to make him or her identifiable. I also wish to advise you that the opening statements you have submitted to the committee will be published on the committee website after the meeting. Members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the Houses or an official either by name or in such a way as to make him or her identifiable. And I'll call on Mr. Cregan to make your opening remarks.
Good morning. Thank you for the invitation to attend. I understand that the committee wishes to focus upon the draft Small Public Service Vehicle Consolidation and Reform Regulations 2014, which have recently been the subject of public consultation. Small public service vehicles include taxis, hackneys and limousines. Following a government decision of June 2011, a wide-ranging review of the industry was carried out, chaired by Mr. Alan Kelly, TD, Minister of State for Public and Commuter Transport. The resultant review report was published in January 2012. The aim of that review was to secure consumer confidence in the taxi system by ensuring that an appropriate regulatory framework is in place which is adequately enforced. The National Transport Authority was given responsibility for implementing the vast majority of actions, and responsibility for the enactment of necessary statutory instruments rests with the authority. Certain actions required primary legislation to be enacted. The Taxi Regulation Act 2013 was enacted at the end of last year, and it included all of the required legislative changes needed to deliver on the review's actions. Some sections of the Act have been commenced, but the main body of the Act is to be commenced in the coming months in tandem with the consolidated regulations. Regarding the draft regulations were released for public consultation on the 19th of December 2013, and submissions could be made until the 31st of January 2014. A total of approximately 242 submissions were received. The Advisory Committee on Small Public Service Vehicles, a statutory group appointed by the Minister for Transport, Tourism and Sport to represent both the operators within the industry and various other relevant stakeholders, will also set out its views directly to the authority. All these views will be considered by the Board of the Authority when it convenes later this month to decide on the regulations. As part of this deliberative process, I will bring back the views of this committee to the Authority's Board. What is contained in the draft regulations? Well, firstly, the draft regulations will consolidate all existing taxi regulations into one statutory instrument, bringing together regulations made over the last 50 years. And secondly, various new regulations have been included in order to give effect to the requirements of the government review. And in the appendix overleaf, I have provided a list of the key changes proposed. And that concludes my introductory presentation. I hope I can address any queries that arise.
Okay. Deputy Dooley.
Yeah, thanks very much, Mr. Cregan. Thanks for attending. Just I have a few areas that I want to cover with. The first thing really is to establish why the decision was taken to enact these regulations by way of statutory instrument. The volume of information contained in the regulations, to me, would seem to be better in primary legislation. From my experience, statutory instruments are used for updating some rules and procedures, but generally not the volume that's contained here. I would have thought that that would have been better enacted as a piece of principal or primary legislation, and that might be a more appropriate way. So maybe you'd comment on that. Just then on the the extent really of what's involved here. Just some concerns again, and I've expressed these at the committee before. From the consultations that I've had with taxi drivers and various groups, there's certainly a lack of belief in the role played by the Taxi Advisory Committee. The information that I would get from quite a diverse group of taxi drivers and representative groups is that it's not working from a taxi driver's point of view, and maybe you'd comment on that at a later stage. Now, just a couple of things. There's concern in the industry around the decision that has been taken by yourselves to introduce a new class of taxi licence, namely a smaller wheelchair accessible vehicle, where you have changed the regulations for the smaller vehicle now that just carries one passenger together with the person in the wheelchair, rather than the previous requirement to have four, and also a decision where you've decided to change the vehicle from having or being 3 years or newer to 6 years or newer, whereas the general understanding around all of the necessity to improve the qualitative nature of taxi was also a way of dealing with the quantitative issue that has arisen because of the proliferation of the issuance of licences, which has had a negative impact on the industry as a whole. And that kind of leads me to a point then in the Indicon report where the suggestion was that in the issuance of a licence that the NTA would outline, if you want, to taxi drivers the fact that there was a level of oversubscription in the business and that it was virtually impossible to make a decent living out of the business. Now that seems to have been excluded from the overall approach that was taken. It's there where in the Indicon report it said that initiatives to produce credible market information to the extent of low incomes and low taxi utilisation in the sector should be implemented and highlighted to discourage uninformed new entrants to the sector. In providing increased market information, it would be beneficial to ensure that potential entrants have accurate information about possible earnings in the sector. Information on utilisation rates and earnings with dispatch firms might also be beneficial for existing as well as potential entrants. That's something that doesn't seem to have been really gotten out there. So there's a few other things that I'll go through, and you can maybe come back to me in some detail then when we get an opportunity to do it. There's concern as well in relation to that new licence grade for the smaller wheelchair accessible unit, that they have to be loaded, for the want of a better word, from the rear, and that may have implications for people seeking to get into the taxi at a taxi rank, and it may have some implications for road safety. So I take your comments on that. Clearly, it seems to be a backdoor way of increasing the volume of licences yet again, and there's concerns that the market will be flooded with this type of vehicle, with no guarantee that it's in any way going to increase the level of response from those with that particular licence grade to attend or to meet the needs of the community who find themselves in wheelchairs. There's an issue then around the dormant or inactive licence, where you have reduced the period of time from 5 years to 1 year. I think that's overly restrictive. I think there are many situations where somebody might find themselves out of the business for a period of time, either their inability to keep a car on the road, may have to just rent a vehicle for a period of time, or through ill health or whatever. So I'd be hopeful that you could find your way in restoring that period of time to 5 years. There's issues then around the whole advertising and this preclusion from the capacity to advertise. I don't see the logic to it, quite frankly, Mr. Cregan. To me, it doesn't appear to be a problem, and I use public transport, I use taxis. I've yet to see anything that I found distasteful or overly commercial. There's a concern amongst some in the industry that it's a way of the NTA taking control, and you'll ultimately charge a fee at a later stage to allow for advertising that you deem appropriate or whatever, and I think that would be a retrograde step. There's issues then about the concern about the way in which dormant licences are being bought up at the moment, being connected to a car within the right age group, in other words within a 3-year period, but being transferred on at a later stage, and it's not helpful to the business generally. There's questions being raised about the driver check application and the capacity, or a glitch in the system that seems to allow a third party to change a driver's details without their permission, and maybe some comments you'd have on that. There's concern about particularly the Lewis construction works in Dublin at the moment, and the damage or the impact that's having on the ranks, and the fact that there hasn't been a suitable level of ranks to replace those. There's concern too, Mr. Cregan, that the industry generates about 5 million by way of license